Hello, my name is Dwayne Kimball, owner and founder of KMD 89 VA Claims Consulting, Leave No Vet Behind, and also I'm a United States Army veteran. Today, I'm bringing you another educational video as it pertains to the VA disability compensation claims process. But before we get into today's video, make sure you like, subscribe, hit that notification button, and also you can find us on Facebook, LinkedIn, Instagram, and Twitter. So today's video, what I'm going to be discussing today is the informal conference on the high-level review. A lot of veterans are filing a high-level review, getting to and selecting an informal conference on the 0996, and then when they get that call from the adjudicator slash DRO slash decision review officer, they don't know the process, they don't know how to reasonably articulate what they're doing or why they file a high-level review. So today I'm going to show you 4 slides, okay? And all these slides is from the M21. And remember, the M21 is not law. It's just a reference or a guide that some VA employees use, but it also can be beneficial to you, the veteran, as it pertains to what we're going to be talking about today, okay? And at the end of, towards the end of this video, I'm going to give you a scenario of how to reasonably articulate why you're filing a high-level review based on what some of our clients have been going through and what I've been discussing with other veterans that called me, okay? So that being said, let's jump into today's first slide. Slide number 1. Here in slide number 1, we're talking about the informal conference, what the definition of an informal conference, okay? An informal conference is contact, typically by telephone, but also using other means that, that VA determines appropriate for the sole purpose of allowing a claimant and or representative the opportunity to identify any errors of law or fact in the prior decision, okay? I'm gonna read that last part again that I highlighted and underlined in red. Opportunity to identify any errors of law or fact in the prior decision. So what they're saying is this informal conference is for you and or your representative to identify any errors of law or fact. Not to get on there and say, hey, I should have been service connected because I served my country. Okay, a lot of us, I agree that we should. It shouldn't be as hard. But what they're telling you, the opportunity to identify any errors. A lot of veterans cannot, when they look at the VA claims process, one, they're not educated on it, so they can't identify any errors or fact in the prior decision. So a lot of veterans don't know how to read that rating decision when they are denied. They go right to favorable findings and say, well, I got favorable findings, so I should have been service connected. It doesn't work that way, okay? So again, opportunity to identify any errors of law or fact. Now, like I said, I'm gonna give you a couple of scenarios towards the end of this video after I go through all these slides, okay? As it pertains to errors of law or fact, all right? So just keep that in mind and bear with me. But again, you always gotta remember, it's your time, that time in the informal conference to identify errors. And that is some examples or scenario I'm gonna give you. I'm gonna identify some errors, okay? Okay, slide number 2. Slide number 2, initial actions. Now, all these are M21 references. When you see things in red, I identified those things in red. And also, remember, these M21s, they come from the VA's website. They may not be the entire M21 reference. So you have the M21 number and the name of that M21. Make sure you do your due diligence and you go to the VA's website because there could be more information as it pertains to these M21s, okay? I just I'm only highlighting some key points, okay? But keep in mind, there could be some additional information. And also another thing in blue, there's 38 CFRs that may have reference to these particular M21 references. So there's some additional research there as well. Now, I'm not going to read this entire M21, only what I highlighted in red, okay? So this M21, initial actions. The reviewer or informal conference coordinator will make a total 2 attempts to contact the claimant or his or her representative to schedule. The reviewer will hold the informal conference within 7 calendar days of the successful contact. However, VA may individually grant extensions beyond the seven calendar days from contact if the pending review is still within established cycle time goals. Please note that the number of attempts made to contact, as well as the timeline for scheduling, conducting informal conferences, are guidelines, not rigid requirements. Again, not rigid requirements, only guidelines. Additional efforts or longer time frames may be justified on a case-by-case basis. The key point is to make reasonable efforts to hold or otherwise promptly resolve conferences. Okay, so keep in mind, they call you, say, hey, we want to schedule a time to do the informal conference, all right? So you make that, they make that date. They're trying to do this within 7 days of making that contact. Now, I've talked to some veterans where they call that day and say, hey, this is your informal conference. So just keep in mind, when you get that call, you want to ask, are you calling me to schedule the informal conference, or are we doing the informal conference now? All right. Now, I previously did a video where I talked about if somebody calls you and it is the informal conference, what questions you might want to ask. Name. Are you the person that's going to be deciding my claim? Which regional office do you work out of? And what's your job title? If in fact that person is calling you to conduct the informal conference, not to schedule it, but those are questions if they are actually going to conduct the informal conference. All right. Now, told you I had 4 slides. We're going into our 3rd slide, slide number 3. Now, this slide on here, we have a little bit more information. So I'm only going to go over what's in red. Okay. Now I post these slides, but you have to keep in mind, you still want to do your own research because every claim is different. Okay. So slide number 3, actions to take after successful contact. Schedule and or conduct the informal conference, preferably within 7 days of initial contact with the veteran. Now, on the last slide, they say these 7 days is not a requirement. It's just a guideline. They could extend it out depending on how many claims they have before yours, okay? The second bullet comment, prior to the informal conference, the decision maker should, keyword, should conduct at least a cursory review of the decision under review so that they are familiar with all issues and the applicable evidentiary record. Now, a lot of veterans I've talked to, when they ask the adjudicator or /DRO, decision review officer, have you reviewed my claim? A lot of them are telling them, no, I did not want to review it and dilute things. I want you to tell me, you know, the ins and outs of the high-level review. Now, or why you file a high-level review. Now, going back to slide 1, remember, in slide 1, we talked about what? That's you or your representative opportunity to identify any errors of law or fact. So now they're saying the informal conference, the decision maker should, again, should, not saying they have to, should conduct at least a cursory review. But the veteran should do that as well. You got a copy of your claims folder. Hey, they denied me this. I'm filing a high-level review. So now you know exactly the what, when, why, and how of what you're doing as it pertains to your informal conference, okay? So the last section I have highlighted, important, and this is a 38 CFR 3.2601, notes that the decision maker with authority over the issues must be the one to conduct the informal conference, except under exceptional circumstances. Exceptional circumstances are significant events such as, but not limited to, the employee resigning or retiring from the VA, reassignment to another position that does not have decision-making authority, or extended period of leave, for example, maternity leave for several months. So basically, what they're saying here, the person that's conducting an informal conference should be the person that's going to make that decision. So again, when I ask that question, when it is this in fact the informal conference? If it is, what's your name? What's your job title? Are you the one that's going to be making a decision on my claim? Now, if they say yes, and that person is on vacation, goes on vacation, or is on leave, or goes to another position that doesn't have decision-making authority, then somebody else may step in and make that decision. You don't hear that happening too often, but sometimes it does. So again, would that be a question that you would want to ask that particular individual? Are you the one that's going to be making the decision? Okay? Now, in the last slide, purpose of an informal conference. The purpose of an informal conference is to clarify the issues the appellant wishes to appeal, provide explanations regarding the rating decision, which evidence was considered, how the evidence was considered, and identify additional sources of pertinent information. Now, this is for the veteran. You have to do this. And a lot of veterans do not know how to do this. So again, clarify the issues the appellant wishes to appeal. What are you appealing? Something that you should have been service connected for? Is it the effective date? Okay, is it the percentage? You as a veteran have to clarify this. Okay, again, are you appealing? When I say appealing, it's high-level review. Okay, I'm old school. So it's a high-level review for service connection for a condition. You have to explain why you should be service connected based on what? Law or fact, from slide number 1, okay? The rating decision. Do you know how to read that rating decision that denied you? Something other than, oh, they gave me favorable findings. Just because they gave you favorable findings don't mean you should be service connected. Which evidence was considered? There's an evidence section in the rating decision. And then how the evidence was considered and identify additional sources of pertinent information. So those slides, they have I know it was a lot. It was a lot of information, but it was valuable information, okay? Like I stated earlier, I'm gonna give you a couple of scenarios, okay, where a lot of this can come into play, all right? Now, one, let's just say you're a veteran and you're service connected for PTSD, all right, at, let's say, 30%, and you don't get any treatment at the VA hospital. You have a copy of your claims file on CD already, okay? You go to a private physician, a psychiatrist or psychologist, or someone that's eligible to complete a review DBQ for PTSD, and you file a claim for increase. You submit that claim, you submit that 526EZ, and attached you have that PTSD DBQ review. And let's just say for all intents and purposes, it's actionable and sufficient for rating purposes, meaning there's nothing wrong with that DBQ, and there's no need for the VA to schedule you a CMP exam. That DBQ is enough information because this action was sufficient for rating purposes. But that VSR, someone schedules you for a C&P exam. Now let's just say you refuse the exam. I'm not saying that you should. Only thing I'm saying is if you feel that you have an actionable and sufficient rating decision, I'm sorry, DBQ, in this instance, you're refusing because you don't want there to be conflicting medical evidence, okay? So you don't go to that exam. So you get the rating decision and they deny the increase. And their only reasoning is you failed to report to that C&P exam. Now they list your DBQ from your private doctor in the evidence section. Now I'm using keywords from this slide, okay? So in the evidence section, they list the DBQ, but in the narrative, they do not give an explanation as to why they did not use it, and they deny the increase. Now, you submit a 0996 for a high-level review. You get a call, they say, hey, Mr. Veteran or Miss Veteran, you filed a high-level review. I'm calling you to confirm or schedule your informal conference, okay? I'm available on X, Y, and Z date, 2 days out, okay? Now you get the call from the adjudicator, decision review officer. And they call you, they verify that it's you. Then they say, I'm the one facilitating the high-level review. My first questions are, okay, what's your name again? What's your job title? Are you the decision review officer? Are you going to be the one adjudicating my claim? And which regional office do you work out of? Last question, have you did a cursory review? Another key words there that was in some slides, in the previous slides. Have you done a cursory review? So then let's say the decision review officer says, nope, I did not do a review. I want to hear from you why you feel you should be service connected or percentage or whatever. Okay, so now the ball is back in my court, the veteran. I submitted an actionable DBQ for rating purposes. I received a call from QTC, LHIVES services, or whoever that wanted to schedule me for an exam. I refused that exam because my DBQ was actionable and sufficient for that rater to rate my claim. In this rating decision dated such and such date, in the evidence section, they noted that they received or reviewed my DBQ. But in the narrative section, the only comment was they stated I refused the exam. That's why they denied the increase, but they did not say why my DBQ was insufficient or why they didn't use it for rating purposes. Therefore, I am stating I would like my DBQ to be considered and granted the higher evaluation as it gives my current residuals as it pertains to my service-connected PTSD. Therefore, no C&P exam is warranted. Do you agree or don't you disagree? And if you feel that my DBQ is insufficient, what makes my DBQ insufficient so I can have my doctor to clarify or update that DBQ. But I believe that my DBQ is actionable and sufficient. So now the ball is in that adjudicator's court to explain why, okay? So that's just a scenario that, something I probably would do. I'm not saying that you have to do it, but I was able to reasonably articulate why I was filing a high-level review and what I felt that should have happened to grant that higher benefit. Now let's just say another quick scenario. You're not service connected, okay? You're not service connected. Your doctor fills out a DBQ and a nexus statement. It's actionable and sufficient. And in both cases, the examiner viewed or reviewed your claims file. That's why I always challenge veterans, get a copy. Why haven't you requested a copy of your claims file? So in both scenarios, your examiners review your VA claims file. So they're privy to the same information that the C&P examiner that the VA wants you to go see that has never treated you and will never treat you again, that they want you to go to, okay? So they looked at your entire claims file. The doctor does a DBQ, nexus statement, same thing happens. They request an exam, you refuse, but that information, for all intents and purposes, is actionable and sufficient for them to make a decision. So the only thing at this point, when that adjudicator calls you, say, hey, my DBQ and nexus statement is actionable and sufficient. And again, in the rating decision, the RVSR did not state why. So now I'm asking you, the decision review officer, what makes my DBQ insufficient? Because no one has stated that in the rating decision. They just refuse to use it for whatever reason. I don't want to go see your doctor because your doctor doesn't treat me and never will treat me. My doctor has treated me and has access to my VA claims folder because I have my CD. Okay, so that's how a couple of different scenarios of how the conversation could go on an informal conference. Now, this is not to say that, yeah, you do exactly what I stated in these scenarios and you'll get service connected, but it's something to, make you think about your claim. Okay, why are you filing a high level review other than, they gave me favorable findings, which means nothing. Sometimes it means nothing. It doesn't mean that they should have service connected you. It could be something as simple as, you have a current diagnosis. But if that current diagnosis doesn't fall under the 5 ways of service connection, guess what? You're going to get denied. All right. So there's so many, variables that, could or could not happen. Okay. But in my opinion, favorable findings, is that grounds for high level review? Could be, but me personally, I would say no, but that's just my opinion. But I gave you a couple of different scenarios where and how you can reasonably articulate why you're filing a high level review, the reasons behind the fact and evidence, and what should happen going forward as you get an increase and or service connection. Okay? So that being said, please like, subscribe, hit that notification button. And again, you can find us on Facebook, LinkedIn, Instagram, and Twitter. So if I don't see you in one of our monthly educational trainings, I'll see you in my next educational video. Thank you.